بسم الله الرحمن الرحيم قل هو الله أحد الله الصمد لم يلد ولم يولد ولم يكن له كفوا أحد صدق الله العلي العظيم.
Thank you, Mr. Naveed Khokar. Once again, I would like to thank the people of Legal Outreach for arranging this program, and our Chairman of Legal Education Committee, Mr. Wasim Saif Khoso, and members of the Managing Committee, Mr. Salimul Haq, and Mr. Altaf Hussain, who are here, who have played a good role in arranging this program. Today's topic is criminal litigation, evidence and sentencing. We will briefly touch these topics, and more emphasis would be laid on the part of recording of evidence and the advocacy skills required, the skill set required for those recording of evidence, for preparation of the case, and for bail applications as well as appeals, because tomorrow also there's a session of criminal litigation regarding appeals and bails, I believe, which is going to be conducted by former Justice Amir Raza Naqvi Sahab. So we will briefly touch the topics of this module. We will start with cognizable and non-cognizable offences. The cognizable offences are those which the police authorities can investigate directly without permission from any quarter, and they can make arrests and start investigations, as opposed to certain non-cognizable offences which the police authorities cannot start investigation or make an arrest without express permission from the competent authority. That authority could be a magistrate, or in certain cases some government officials or some government department. Most of the cases in the Pakistan Penal Code are cognizable, except for a few, particularly those which relate to offences against the country, against the state, treason charges or offences against public servants regarding bribery and corruption. They require permissions. Otherwise, most of the cases in the entire Pakistan Penal Code are cognizable, and police can take cognizance of them, record the FIR on their own, start investigation and make arrests without any specific permission. I will briefly touch the topics given here because they are very basic. The process of giving and storing information in a cognizable offense, I believe most of you would be aware that if you have any information regarding any offense, you first of all report it to a police officer, and the police officer reduces it into writing in a certain format which is provided in the Criminal Procedure Code, and then he writes it in a particular book, official book, by that officer, a certain prescribed book. And likewise, in a non-cognizable offense, the procedure is the same, except that thereafter permission has to be sought from the concerned magistrate or the competent authority. The authority of investigation into non-cognizable cases, as I said, would be with either the magistrate or the competent authority of the state. And when the magistrate or the competent authority orders, then the offense would be investigated and arrest can be made in the same manner as if it were a cognizable offense. The procedure would be the same. Now, what happens after the first information report is lodged? We say that the criminal investigation is set into motion. Any investigation can only commence after the report is lodged under Section 154 Criminal Procedure Code, which we commonly call the FIR. Most of the people laymen are not aware of the definition of the FIR. It's the first information report. The common man is not aware. They normally say FIR, Katwani FIR. So from there on, the investigation of the police starts, and the investigation includes the recording of statements of witnesses, of people. Witnesses are those persons who are likely to know about the incident, and the collection of information by the police so that the procedure can commence. And the statements are recorded under section 161 CRPC. There is a certain methodology to recording of statements. It has to be written down and signed by the investigating officer and not by the person who is giving the statement, because it cannot be held against him in the court of law. The duty of the person who is being examined is that he has to answer all the questions which are cannot be compelled to give information against himself, which, as we call it, he cannot incriminate himself, he cannot give any information, he is not bound to give any information which can incriminate himself. Now the next is the powers and duties of justices of peace. Now, justice of peace is a term which is often misunderstood. People think that justice of peace is a judge. A justice of peace is not a judge. A justice of peace can be any person who has been given specific powers in this regard. This is just another layer in the criminal administration of justice, where if the police is not cooperating with the complainant or any person who can give information, or the police is not assisting him in doing its duty which that person wants, it could be a complainant or any other person, there is a recourse also to the justice of peace. The justice of peace is specially designated. Some of the lawyers are appointed justice of peace. The session judge is appointed for the purposes of sections 22A and B CRPC as justices of peace for certain specific purposes, and the purpose is that there should be another layer which can assist the common man, assist the complainant. If the police is not cooperating, the justice of peace has the authority to direct the police to do certain things which they are bound to do. So that is an intermediary role. You don't have to go to the justice of peace. You can come to the court in a constitutional petition under the writ jurisdiction of the High Court under Article 199 of the Constitution for such purpose, and that remedy is also available, but that is an intermediary remedy available as far as justice of peace is concerned. An FIR can also be lodged through a justice of peace through the intervention of the justice of peace, and he can also prevent anybody from escaping if somebody is accused, and he can also apprehend a person based upon a certain complaint, upon a certain information, and he can commit him to custody by the police. He can direct the police. The competent authority, as has been defined, the justice of peace is also a competent authority, and if the police officer is called in aid of the justice of peace, in aid of the complainant, in aid of the investigation of the case, the police is bound to assist all such competent authorities. And the duties of the justice of peace, as I just mentioned, they are given. What are the duties of the justice of peace? A, when justice of peace receive information regarding the happening of any act that involve breach of peace, the justice of peace has to immediately make inquiries. He has the power to make inquiries. He can write a report and make a complaint to the nearest magistrate. And if it's a cognizable offense, he can secure the place of occurrence. He can prevent any items from being removed from the place, again to secure evidence. The justice of peace has to aid the police officer in making such investigation. He has to record the statement. He has all these powers. Next, I'm just quickly skimming through these because my thrust would be mainly to come to the part of evidence, but this is the part of the material, so I'm just quickly skimming through it because my emphasis would be to not to tell you the law, because you can read the law from the books. My purpose is, my objective is to give you advocacy skills based upon my experience and based upon the experience of my seniors. Law can be read from the books, understood with your friends, with your seniors, you can understand it. But I believe if you are a litigator, if you are a litigation lawyer, then you need a certain skill set for doing proper advocacy, to do justice to your clients, to make your best appearance before the court and try to get the maximum result out of your effort. So that should be the main purpose of an advocate. Coming to the complaint, private complaint and direct complaint, essentially they are different words for the same. The private complaint and the direct complaint are more or less the same under section 200 CRPC and 202 CRPC. The methodology is provided. The magistrate can examine a complaint if you file a complaint. Many people ask this question that what is the difference between an FIR and a direct complaint? You have, first of all, you have the option. You can get an FIR lodged for a cognizable offense, or you can also file a direct complaint. The procedure is slightly different. In the case of an FIR, the police is going to investigate the entire case and submit a report before the competent court, and the trial will commence. In the case of a private or direct complaint, the concerned magistrate will hear the complainant. He will record his statement under section 200 CRPC, and thereafter he can make preliminary inquiries, and the evidence would be recorded in court. If it is an offense which is cognizable by the magistrate, he will commence the proceedings, or if after recording the statement of the complainant he is of the view that his court is not competent and another court is competent, he can transfer the case to that another court. So you can read out the magistrate when to re-examine a complainant, the procedure of competent notice. If he is competent, he will proceed. If not, he will send it to the competent authority. When can the court delay the issue of process? Until and unless the court is satisfied from the contents of the statement of the complainant that a case is made out. Until it is satisfied, it will not issue the process. The process is summoning of the witnesses or the accused, because in the first instance, the accused are summoned to appear before the court. If they do not appear, then bailable warrants. If even then they do not appear, then the courts will issue non-bailable warrants. Section 4 is seldom used. I have yet to see a case where Section 4 is used. The powers of persons other than JOP, magistrate or police officer investigating a case, they can be used in case where the magistrate, in case of a complaint, feels that a certain private person has more capacity, more expertise to find out about a certain matter, then he can assign, he has the power to assign that matter to a private person to inquire into that matter and submit his report before the concerned magistrate. And that is evidence. Evidence in any case, whether it is criminal or civil, is of utmost importance. So all attention has to be made at that stage of recording of evidence, because once evidence is recorded, all requirements are fulfilled, legal requirements are fulfilled, and once evidence is recorded, that evidence is going to be the part of that case right up to the level of the Supreme Court. There was one case that was a preemption case in which my client, he lost the case before the concerned civil court. Thereafter, an appeal was filed. He lost that appeal as well. And a revision was filed. He lost that revision as well. So there were 3 concurrent findings against him. And he approached me to go to the Supreme Court, because the next 11th and the final forum was the Supreme Court. On the face of it, I saw the case. I said, you have 3 concurrent findings against you, and there is not much which on the face of it I can see. Why would the Supreme Court overturn these 3 concurrent findings? He was a layman. He said, I don't know, sir. I have come to you. You have been highly recommended, so kindly you take my case. I refused. He came back after 2 days. I again told him, I refused. He again came back after 4-5 days, this time bringing 2-3 of my friends to tell me that kindly take his case. I explained to him as well, my friend, he was a lawyer. I told him that I don't see how I can help him in any case, because he will spend a lot of money, he will pay my fees, but at the end of the day, I do not have any faith in confidence in these documents that I will be able to get something for him. But his insistence and his bringing of friends, I said, okay, give me a couple of days. I went through the file thoroughly in the night, each and every page. And there was just one point in evidence which I thought that might be able to, I might be able to influence or convince the judges that this is a point in which some relief might be available to me. And I told him very categorically that there's a very slim chance, hardly a 5 to 10% chance, if you want to take that risk. And unfortunately now in retrospect, I quoted him a very less fees. So I prepared that case, went to the Honorable Supreme Court, and that point clicked with that bench, and all 3 concurrent findings were set aside, and even interim order was granted in his favor. So sometimes luck also plays a part, and one small point in evidence recording which was done 10 years back. The person, the opponent, the respondent, who had for 12 years, he had managed to succeed at every forum. He lost that case in the Supreme Court just because of a small lacuna in the recording of evidence. And that prevailed with the Honorable Supreme Court, and they set aside the case. And that is why I emphasize, and everybody should focus, that the evidence before the trial court, whether civil or criminal, is of utmost importance, and full attention be made on recording the evidence in a proper manner. Now, evidence in trial. Now, once, just briefly going back, once the FIR is lodged, investigation is complete, the police will submit a report under section 173 before the competent court, 173 report, in other words, commonly known as the challan. The challan is submitted, thereafter copies are supplied, and charge is framed against the accused, nominated accused persons, and they will plead guilty or not guilty. And thereafter the trial will commence. The trial will commence only after framing of charge. Many lawyers even don't know that. What is the trial? Trial starts after framing of the charge. So once the charge is framed, the trial will commence, and that includes witnesses, recording of evidence. In a criminal case, normally, as is the case, the complainant is examined first. Now the order of examination is also given in 2.2 and 2.2.1. In fact, the order is complainant's examination in chief, complainant's cross-examination by the defense counsel, re-examination. Now re-examination. The complainant, when he comes in the witness box, first of all, his examination in chief will be conducted. After that is concluded, the cross-examination by the defense counsel. Now, one important thing here, when the examination in chief is being conducted, the duty of the other counsel, that is the defense counsel, obviously that will be counsel for the accused, because the prosecution will lead its evidence first always. So the defense counsel has to be very watchful. I normally see in the trials, when the examination in chief is being conducted, the defense counsel just looking at his books, looking here and there, whispering with other counsels, or just playing on his phone, or talking, or just looking, doing something else. His complete focus should be on the demeanor of the witness, exact words which he is saying, the words which he is saying, how they are recorded by the presiding officer. His entire focus should be his concentration should be on how the evidence is required, because these small bits and pieces of attention are going to pay you great dividends in the long run. You will know when a wrong word is being used, what maybe he's Urdu mein bolte hain, is translated into English, a different word comes which changes the complete complexion of the sentence. But he doesn't, for lack of knowledge or lack of attention, he lets that pass, and ultimately when the trial is concluded, when they go through the evidence, they see, oh my God, this is not what I had said, and this is not what the witness has said. Why has the judge written that? So if you are sincere to your client, if you are sincere to your profession, and if you sincerely want to rise in the ranks of the professional lawyers, you have to pay close attention at the time of evidence. Because normally senior lawyers don't go to the trial courts. I tell the senior lawyers, kindly go, even if you don't proceed with the case, if your associates are proceeding with the case, at least you should go there for a few times so you can guide them. You can guide the juniors what attention he needs to pay, what notings he needs to make, what questions he needs to ask, or whatever he's asking, you can correct him and thereby rectify his faults so that he can become a good lawyer. If you are not a good lawyer at recording evidence at the appeal stage, whether at the High Court level or the Supreme Court level, you will always stumble. There are certain barristers I know, certain lawyers who say, no, I don't want to go to the trial courts, the conditions, the atmosphere is not good there, whatever the reason. If you do not conduct trial yourself completely, you will never be able to be a good appellate side lawyer. You need to know how the evidence is recorded. Otherwise, when the evidence comes to you, you do not have the background of getting the evidence recorded. What will you do at the appeal stage when you are reading the evidence? You will not have the background of the atmosphere of the court. How will you interpret that evidence? So you need to go. I still go to the trial courts. Initially, when I started my practice, the first 3-4 years, my late father told me, you stay in the city courts, you stay in the trial courts, you do not come to the High Court. You have to go through that process until you see it, even if it is for only 1 year or 2 years. You should conduct trials. Without conducting a trial, you will never be a good appellate side lawyer, whether it is civil or criminal. So coming back to this, there's a complainant's examination in chief, and for cross-examination, re-examination is when the complainant's counsel can assure the court, can show to the court that while conducting the cross-examination, certain facts have come to light which need re-examination, and if the court allows, then the complainant side can re-examine the witness. Normally, if you see the evidence, it is written no re, that is re-examination. And if it is re-examined by the prosecution side, then the defense counsel also has a second chance at cross-examination. Now the types of witnesses. There are broadly 3 categories of witnesses. One, it is defined here as a lay witness, or we can call him an eyewitness, or one who can give an ocular account to some extent of the incident. Is the most common type, who has seen something. The second is a specialist or an expert witness. It could be a doctor, it could be an engineer, it could be someone, a forensic expert who has conducted something. Cybercrime cases in which the experts of computer experts are brought in to give evidence. They have done forensic of the laptops or the mobile phones. They are expert witnesses. And the third type is a character witness. Because sometimes the character of a person, of a witness, if you are able to establish a certain character of a witness, depending upon your case, that can help you in obtaining success in your case. Because if you hit the character of the witness, if you can create enough doubt in the mind of the court that his background, his character is such. For example, a stock witness we call it. There were times, I believe there still are, that police, just to create evidence, they got a stock of people who they bring sometimes as witnesses. Yes, we saw that. yes, we saw this incident. They have never seen that incident. But they are like regulars of the police. So if you are able to establish before this court, or you can ask him that Mr. So-and-so, in 10 other cases also, you have given evidence on behalf of the prosecution in different cases. So if the judge comes to the conclusion, yes, this is a regular witness of the police, so his credibility is disputed and he can be disbelieved in that account. So that is the character of the witness. You can bring that evidence, though those 10 cases have no relevance with that instant case which is before the court. But the credibility of the witness can be affected. In the past, what he has done, what his character has been, how he has conducted himself, if you are able to bring on record, you can damage his credibility, then that is called the witness of the character. Cross-examination of complainant and its witnesses. Now, when I started the trial court, and we normally appeared for the defense counsel, so we were normally cross-examining the witnesses. So my father said one thing. He said, now you are going for the trial, remember one thing. I said, what are the questions which I need to ask? He said, more important to understand is what questions you should not ask. That is the most important thing. And the books, if you read on cross-examination or evidence, it is normally they are titled The Art of Cross-Examination. It is an art, it is not a science. If it was a science, you have a big book, you have the complete FIR, you have the challan, you have the documents, you can ask him everything. But that anybody can do. So the art is, the secret is, you have to understand what questions you are not supposed to ask him. That is very important. Just to impress our clients, sometimes we ask questions, 10 questions, 20 questions, 30 questions, when they are even not even required. And then we turn back after the case, we tell the client, see, we spent so much time, we worked so hard, we asked him so many questions. An incident happened with me, and this, my father's advice was in my mind. I don't exactly remember the case, but I remember the incident. There were a number of accused. I was representing one or two accused at that time. And there was a detailed examination in chief by the prosecution. That probably took an hour, hour and a half. So when it was my turn to cross-examine him, I just asked him 2 questions and sat down. So my client was upset with me. He said, the prosecution took 1.5 hours and you just took 2 minutes. I said, just wait patiently, we will talk later out of the court. He was upset with me within the court. Then when I took him outside, my father was alive at that time, I said, let's go to the office and we'll talk. So my father asked me, I said, these are, I took the copy to him. He said, yes. In fact, my father said, why did you even ask him these 2 questions? I said, if my client is upset, I just asked him a few questions. If I had not asked him anything, my client would be upset right then and there. So the important thing is what not to ask. You have to, you see, to start the examination or cross-examination of the witnesses, you need to understand your case inside out. What are the documents available to you when you are ready for cross-examination of a witness? Say you are a defense counsel. You have the FIR, you have the challan, you have the 161 CRPC statements of the witnesses, and you have been provided the documents at the time of framing of the charge, which the prosecution intends to rely upon at the trial. The prosecution cannot go beyond the documents which they have provided to you. Now, once you get these documents, what normally the lawyers do, they just close it. When the time of evidence comes, we will take these documents and go there, and depending on whatever the witness is saying, we will start our cross-examination. That is not the proper way to lead the evidence. You have to sit down, take out all these documents, start with the prosecution story, prepare your defense version. You have to set up a defense. You have to set up a defense. You cannot rely on failures of the prosecution. You have to set up your defense, what your defense is going to be, what your line of questioning is to be, from which witness, what questions you are going to ask. Say for example, 161 CRPC of a particular witness is available with you. You will read out that 161 CRPC statement and you will in your mind prepare a defense. Okay, if these are the things which he is going to say, then what will my defense be? How is going to ultimately affect my case in the end? Because after the examination of witnesses, after the evidence is complete, after the arguments, at the time of arguments, you will have to argue your defense. And that will be based on the entire evidence which has come on record. And half of that evidence, the cross-examination part, is your doing. You have recorded that, you have conducted that cross-examination. So the burden is upon you that from that cross-examination, let us suppose that prosecution has led its case very nicely. Now the burden is upon you. Normally in some cases the prosecution does not discharge its burden, so your work becomes a little bit easier. Because the first and foremost duty is of the prosecution to establish any case beyond a reasonable shadow of doubt. But presume that they have discharged their burden. Now it is up to you to shift the burden. And that can only be done if you've got the cross-examination nailed down. If you have not, then you will just argue, sir, he has not done this, we have not done this, he has not done this. That's all, we did our duty. You can argue for 10 hours without substance. But if you have proper substance, even half an hour's arguments are sufficient. Don't waste your time or don't waste the time of the court. Don't just linger on the proceedings, because the defense has, like I said, in the case of the evidence, you have to know what not to ask. Likewise, in your arguments, you have to be very brief as possible. The more you talk, the more help you give the prosecution, the more material you give to the prosecution to play with. So until and unless the prosecution has proved its case to the hilt, until and unless that has happened, you keep your evidence, you keep your cross-examination, and you keep your arguments to a bare minimum. When I was learning to drive a car, my father taught me how to drive a car. So when I was putting the reverse gear, I used to reverse a lot. So he said, remember, don't reverse, even if there's a lot of space, more than is necessary. So likewise in law, he said, don't argue more than is necessary, than more than is required. The more you talk, the more you say, the more you'll flounder. So you have to take care of that. Now the leading questions, and when are advocates not allowed to use them? Everybody knows what the leading questions are. Okay, leading questions are those questions which this normally happens with the prosecution. The leading questions are when the prosecutor asks a certain question which is relevant to the fact of the case, whose answer is relevant for the outcome of the case, and the answer is contained in that question. Just like giving a hint. So that is disallowed, because you cannot put words in the mouth of the witness. So leading questions are those in which the answer is contained in that question, so that it is easy for the prosecution witness to give an answer, because the answer is already contained in that. So they are disallowed. So these are leading questions, and that will be the decision of the presiding officer. Article 136 of Qanun-e-Shahadat order says, any question suggesting the answer which the person putting in wishes or expects to receive is called a leading question. Leading questions are put forward by lawyers primarily when discussing contentious matters with the complainant. Thus, their use is strictly regulated under Article 137, forbids the asking of leading questions in an examination in chief, and even in re-examination, except when the court allows. Leading questions are allowed only in the case in questions which are introductory, which introduce something, certain fact, and which are undisputed, which are admitted facts. I mean, nothing averse to the defense can happen in that. As mentioned above, in a cross-examination, undermining an opponent's witnesses by showing them to be unreliable, unworthy of belief, and having inconsistencies with the accepted evidence in the case, or the evidence they are providing is the objective of the advocate. Leading questions are thus allowed to be asked in cross-examination, because they will not be, you will not ask questions which are going to benefit the prosecutor, or you should not. Sometimes lawyers do. Sometimes in examination in chief, he has forgotten something against you. So it is not the job of the defense counsel, by hello, you have forgotten this question, you add this. Don't create more ammunition against you. Don't create more material against you. If he has not taken your name, forget it. And another thing, even at the time of framing of the charge, another thing we learned from the seniors, if the prosecution makes a mistake, either in the framing of the charge, or some legal lacuna is left in evidence, or the charge, or in any document, some advocates, I have seen some defense counsel in the exam say, sir, this is wrong, kindly correct it. You have to have enough sense to understand that to let certain lacunas be left on the record, because even if they are not helpful to you in that court, at the appellate forum, every little lacuna of the prosecution is going to help you. So why are you filling up the lacunas of the prosecution? There are certain irregularities and there are certain illegalities. The difference between irregularity and illegality is that irregularity can be rectified, but the illegality cannot be rectified. Or as is used in section 537 CRPC, certain illegalities are curable and certain are not. Sorry. Section 537 CRPC, many people are not aware of it. What is a curable illegality and what is an incurable illegality? If you want to be a good trial lawyer, you should go through section 537 CRPC, and not only that, there are few judgments on section 537 CRPC, which if you would go through, you will understand that when a prosecution makes a mistake during the trial, during recording of evidence or framing of charge, let it be. You are not there to rectify the mistakes of the prosecution unless they affect you adversely. Then you can point it out, because if you are prejudiced, if the defense is not prejudiced, and defense, it would be helpful to the defense either at the final arguments or the stage of the appeal, then you should let that lacuna and defect be in the prosecution case, because that's going to help you. So as cross-examination, as we discussed, when you bring a character witness, then you can show them to be unreliable, unworthy of belief, not to be believed. Or what are some people still don't know, what is the purpose of section 161 CRPC statements? They say they are recorded, but they are not used at the trial. So what is their purpose? Even some lawyers ask me. I said, they are not for the prosecution, they are for the defense. 161 CRPC statements which are recorded by the police during investigation, the police can build up their case, but at the court, when the trial commences, the prosecution does not use 161 CRPC statements in any manner. It is for the defense to point out the contradictions. If the witness improves from his 161 CRPC statement in the court, you can confront the witness that you said in your 161 CRPC this A, B, C things, and now in the court you are saying X, Y, Z things. So that is to confront the witness that you are unreliable. Previously you said something else, now in the court you are saying something else. So that many people don't know that 161 CRPC statements are mainly used for the benefit. The defense can use them. Obviously, if there are no contradictions, then you don't have to use them. So, evidence can only be recorded properly, the cross-examination can be conducted properly only if you know your entire case. And you have to know your entire case from the time the charge is framed. Once the charge is framed, it is your duty as a lawyer, okay, now I have to prepare my entire case now. So as and when the witnesses come, you have the overall picture in your mind. What will happen is, if you prepare in piecemeal, then one witness will come, you will cross-examine. After some time, another witness will come, then you will say, oh my God, I should have asked that witness this question, and that is how these two witnesses would be connected. So you would lose that chain. You see, we have to do justice to our client and our profession. We have to work hard. It requires labor. And if you want to be a good lawyer, if you want to progress, you want to be known as a good trial lawyer or a good litigator or a good appellate side lawyer, you have to prepare your case. You have to put in the hours, you have to burn the midnight oil, as they say. If you don't know the facts of your case, please don't proceed, take some time, go and prepare yourself. Because your carelessness, your little carelessness is the difference between the liberty and custody of your client. He is relying upon you. Whether he has committed a crime or not is a separate ethical debate. We are not going to do that. Right now, it is your conduct as a lawyer when you have accepted the brief. It is your responsibility to do your best. I have seen my late father worrying at night. I said, why are you worried? He said, tomorrow there's a case, I don't know what's going on. I'm just going through my mind what to say, what not to say, how to help him, because that is, he has signed my wakalatnama. I have accepted his brief. It is my responsibility now. It should not be on my conscience that because of my shortcoming, he suffers. I should be satisfied that I have done my best. The rest, whatever the decision. That is not my responsibility. And he also told me, you just do your best. You should be satisfied that you have given your best shot. The rest, whatever the decision, right decision or wrong decision, is out of your control. What is in your control, you should prepare. You should do your best. So we owe a responsibility to ourselves, to the profession, and to God, and to our client. That we have to do because of our shortcomings. I have seen some lawyers who are so careless in recording of examination, and ultimately because of their lack of preparation, a person is convicted and behind bars, who he spends a few years or few months behind bars, and the stage of appeal, somehow some things come forward and he's let off. But why did he spend that few months or a year, 2 years in jail? And that counsel is not even bothered. That is the downfall of this profession, and this is a downfall of that person as a lawyer. He is never going to rise if you don't think that you cannot give your best. You are not giving your best. You have to give your best shot. And examination in chief and cross-examination, they are the backbone of any case. The entire judgment is going to be based on this evidence, not on your final arguments. Your final arguments will also be based on this evidence. So this is the time to work hard, not at the stage of final arguments. So these are some of the tips about, yes, can a person be questioned about their previous statements which submitted in written form? Yes, he can be questioned as to anything. Should the accused be present when the evidence is taken? Invariably, yes, unless there could be other reasons. There is a case, I am proceeding in NAB court. There is one of the accused. He was an employee in some company. That company, the entire management was charged. He was also charged with the offense. We were conducting his trial. And that company wound up, so he was unemployed. So he managed to get a job in Saudi Arabia. So I said, we will try that. I found one precedent. We researched and found one case. And we produced that case before the NAB court. And it so happened, it was lucky the judge, the argument was that this person is unemployed. He is not getting employment. He's a poor person. He is getting this employment in Saudi Arabia. This is the offer letter. But he cannot go and come back on every date of hearing. So he may be condoned. His personal appearance may be condoned. The judge was kind enough. There was certain law to that. He condoned his absence. He is still working there and the trial is still commending. But in his place, some counsel or some pleader has to be nominated who will attend in his place. So not necessarily the accused, but invariably the accused is present. Recording of evidence in inquiries or trials, essentially the procedure is same, the principle is the same. Be prepared. And remember, on the basis of evidence, the outcome of the case is hinged. So your preparation at the time of evidence is going to go a long way. The evidence of each witness shall be recorded in writing in the language of the court, or if he is speaking in some other language, normally it is in English, but if it is in some other language, so the judge will translate it into English, but English is not our mother tongue, so there can be some words which can have different meanings in the other language and different meanings as English. So again, the defense counsel has to be very careful. He has to listen carefully what the judge is dictating after hearing the statement of the witness. Pay very close attention. I'm informed that we can take a break for 10 minutes. So there's some tea, I think. Tea is being served at your places. So congratulations. We will have to go there and get the tea. But you are lucky you will be served at your place. Thank you. Welcome back.